So I'll start off in that order. Mark, you first for 5 minutes, and then Ms. Hallett, followed by Professor Kogan, and then Professor Butler, and then Brandon. Thank you.
Thank you, Mr. Chair, members of the committee, for the opportunity to address you on Bill C-9. I bring the perspective of someone who's been involved in combating anti-Semitism for 40 years, in training police and prosecutors across the country on the availability of criminal measures to combat hate, and on having appeared before this and other parliamentary committees and in the Supreme Court of Canada on multiple occasions respecting hate-motivated crimes and on the constitutionality of hate legislation. I'm currently chair of the Alliance of Canadians Combating Anti-Semitism, which is a nonpartisan coalition of over 60 community organizations, Jewish and non-Jewish, a number of which will be filing written submissions supporting the position that I outline for you today. I've already provided the committee in writing with a detailed legal analysis of the legislation and my recommendations. So in my introductory remarks, I wish to make only 5 points. First, I support several of the components of Bill C-9 as enhancements to the existing criminal law, particularly the creation of a hate offense for those who commit conventional crimes motivated by hatred. Creation of such an offense appropriately labels offenders for the purposes of their criminal records and makes more likely the imposition of true deterrent and denunciatory sentences. I also support the new offenses of intimidation and obstruction, not because they criminalize conduct that would otherwise not be criminal, but because I know that the creation of these new offenses, having spoken to officers, will incentivize police to prioritize and address hate-motivated crimes targeting vulnerable community spaces. You will hear some people and organizations contend that these provisions violate the Charter. Similar arguments were made by those who oppose the creation of the current hate propaganda sections of the Criminal Code, and I was there. Those arguments lack merit in relation to the proposed hate offense, especially if the definition of hatred were to attract precisely the language adopted by the Supreme Court of Canada in upholding limits on freedom of expression. The intimidation and obstruction sections, if anything, more carefully protect lawful protests than existing provisions that might be used under the Criminal Code based on the specific intent required to prove each of these new offenses. Second, although the removal of the Attorney General's consent is intended to streamline hate propaganda prosecutions, which makes the proposal superficially attractive, it would be dangerous to remove that requirement altogether. The consent represents an important safeguard against vexatious and frivolous misuse of the hate propaganda provisions. The Attorney General's consent requirement should either be retained as is or retained in relation to private prosecutions only where the dangers are most acute. And as I've set out in my written materials to you, there's precedent for that very approach to be taken. Third, the existing wording of the new offense pertaining to the display of symbols raises a number of issues I've identified in my written submissions. I believe that a carefully crafted provision can address the display of terror symbols more effectively than the proposed legislation. The proposed legislation must also be amended to better protect the symbology of Hindus, Jains, and Buddhists. Fourth, there is a significant omission in the legislation. Namely, there's a need for the creation of the offense of willfully promoting terror activities or the activities of a terrorist group. I explain in my written submissions why such a provision is fully compliant with the Charter based on existing jurisprudence and would focus not on which identifiable group is or is not targeted by hate speech, but on speech that supports violent terror activities unprotected under the Charter. And finally, the real issue that we cannot lose sight of is enforcement of existing laws. We are underutilizing existing criminal law measures. This committee should signal that all governments and law enforcement must work cooperatively to ensure that law enforcement utilize the tools they already have available to them, as well as any enhancements this legislation may add to address pervasive anti-Semitism in Canada and other forms of hatred. Just over a week ago, a man pled guilty in a Toronto courtroom to multiple terrorism-related offenses for conduct that included his authorship and distribution of manifestos on behalf of a white supremacist hate group. These manifestos were cited by criminals around the world as justification for heinous crimes they committed. The manifestos advocated violence, including sabotage of critical infrastructure, murder of police officers, high-profile assassinations. The prosecutor described the manifestos to include radically anti-Semitic material and incitements to hatred against LGBTQ+ individuals, Jews, and people of color. The Supreme Court of Canada over 34 years ago recognized the need to place limits on freedom of speech to address the most virulent forms of hatred, because such speech not only marginalizes vulnerable Canadians, but attracts adherents to extremist, sometimes violent ideology. The proposed legislation, with appropriate amendments, represents one step forward in addressing the epidemic of hate crimes that threatens the safety and security of all Canadians. Thank you, Mr. Chair.
Thank you. Ms. Hallett.
Thank you. Good evening, Mr. Chair, and thank you to the committee for having me. The CTF-FCA has spoken at committee a number of times in recent years, and we always appreciate the opportunity to bring our perspective on issues that impact children, students, educators, and their families. My name is Cassandra Hallett, and I am the Executive Director of the Canadian Teachers Federation. Our organization represents over 370,000 education workers and their families, with members in every province and territory in Canada. While we represent teachers and educators from coast to coast to coast, I want to begin with the vision of the Canadian Teachers Federation. A Canada where every child has equitable access to quality public education. For us, among other things, that means every child gets to attend school without fear of intimidation, harassment, or hatred. Unfortunately, the CTF-FCA and our member organizations in every province and territory have observed a rise in the level of what we feel is hate-fueled language and protest in Canada. This language has manifested itself into a climate where students and school staff no longer feel completely safe. Educators and teachers have been targets of public pressure to stop teaching topics in provincially or territorially mandated curricula, such as climate change, the importance of racial or gender inclusion, or the value of gender equity. There has been an eruption of distrust in educators, with the public questioning whether the protection and well-being of students is a priority. This lack of trust is shocking, not only when you consider the fact that the overwhelming majority of educators enter the profession because of their passion for teaching and educating, but also because most education workers are more likely to have children of their own than workers in any other industry. The newfound skepticism education staff and students feel leaves education staff and students feeling like school is no longer the safe and protected space that many people previously believed was the norm. The issue concerned CTF-FCA members across the country so much that a resolution was passed at our annual general meeting in 2023 calling for governments across the country to create, quote, safe zones around schools that made it an offense to hold protests that target or intimidate students and/or staff on the basis of their gender identity, sexuality, race, religion, or other protected category. Children, educators, and their families deserve to go to their places of learning and their places of work with the knowledge that intimidation and hatred will not be tolerated. Bill C-9 is seeking to address intimidation felt by those attending an educational institution. The legislation even specifies daycare centres, and we commend this aspect of the legislation. Children and families deserve access to education without the prospect of feeling unwelcomed because they identify with the groups mentioned. This sense or state of safety is something that we unfortunately have taken for granted in Canada. It is saddening to note that protecting schools from discrimination needs to be explicitly outlined in legislation. But this is the moment we find ourselves in. The CTFFCA does support the intent of this part of the legislation. The issue of combating hate is very important for us and for teachers across the country. We've recently worked with the Canadian Anti-Hate Network and have shared some of their resources amongst our members because of the alarming rise in discrimination, xenophobia, anti-Semitism, Islamophobia, and gender identity-based hate all across the country. The global political climate has ushered in a new era of divisiveness and animosity. Whatever the reason for this swell in division, children should never be on the receiving end of aggressive shows of disagreement. A school needs to be a sanctuary. Many people understand that school should be a special place that's outside of the acceptable places to air your grievances or concerns. As a federal organization representative of educators, we will be the first to say we stand in line with any legislative change that makes schools or classrooms safer places to learn, play, and work. However,
Ms. Hallett, you're way over 5 minutes. Do you have?
I'm
can you
sorry.
Briefly get to the end of it, and we'll
Okay,
be
I
able
am
to ask you the
almost
questions
there.
about that a little later. Yeah.
Thank you. I'll just note that we do recognize the legislation requires more review. We look to the positions of other organizations, including our partners, such as EGAL, the Black Legal Action Centre, the Canadian Muslim Public Affairs Council, or the Canadian Labour Congress, who have legitimate concerns with this legislation. And I will stop there out of time. Apologies. Thank you.
Thank you. Professors Kogan and Butler, 5 minutes total amongst you two.
Mr. Chairman, members of the committee, thank you for this opportunity to share our insights and expertise about anti-Semitism as you review Bill C-9. I'm Dr. Deidre Butler, Associate Professor of Jewish Studies at Carleton University.
Bonjour, Monsieur le Président. Je m'appelle Carrie Kogan. Je suis professeur de psychologie clinique à l'Université d'Ottawa.
Good afternoon, Chair. My name is Carrie Kogan, Professor of Clinical Psychology at the University of Ottawa. We are co-founders of the Network of Concerned Canadian Academics.
Promotes academic freedom, research excellence, and intellectual pluralism to counter anti-Semitism. Our network includes over 400 faculty members on 52 Canadian campuses.
We speak to you today as scholars. For over 3 decades, universities and colleges have been the front lines of contemporary anti-Semitism in Canada. Since October 7th, 2023, our members describe campuses where anti-Semitism continues to surge unchecked and where Jew hatred is normalized, often under the guise that this is political speech or protected by academic freedom.
NECA unequivocally affirms the urgent need to strengthen academic freedom, a right which must be exercised with academic responsibility. Critically, academic freedom cannot supersede the law, including hate speech laws. As experts on anti-Semitism, we submit examples from Canadian campuses. These illustrate the pressing need to clarify, update, and strengthen hate crime legislation to address bias, prejudice, and hate against all minoritized groups.
Too many Canadian professors and students promote violence and hatred, express support for the ideologies of designated terrorist organizations, and demand the exclusion of Zionists. Their definition of Zionist is defamatory and bears no resemblance to the actual meaning of Zionism that is an integral part of Canadian Jewish identity. Hate directed against Zionists is hate directed against 94% of Jews in Canada.
When hate is normalized, bad actors are emboldened. From hostage posters shredded and pins stuck into the photos of infant and elderly hostages, to vandalism and mischief, including shattering windows, breaking into buildings, spray painting hateful graffiti, defacing dorm rooms, and disrupting classes. These crimes are divorced from their intent and impact when they are not recognized as crimes motivated by hate.
Campus encampments displayed signs saying "No Zionists Allowed," restricting access and excluding many Jewish and other students. On November 9, 2023, the anniversary of Kristallnacht, students at several universities held protests with posters showing a foot smashing through glass to evoke the historical trauma of the Holocaust. At one university, faculty and students sheltered in offices under security, but still had to walk through a screaming crowd to attend classes. Just 2 weeks ago, an angry mob of students swarmed a small group of Jewish students who were holding a memorial for those murdered on October 7th. Across Canada, student groups on social media continue to call for the exclusion of all Zionists from campus.
The glorification of terrorism and anti-Jewish hate work together on our campuses. Consider how an encampment sign demanding resistance against the Zionist entity by any means necessary was prominently featured while a masked man proudly flaunted a Hamas bandana. To be clear, Hamas is a recognized terrorist organization. Hamas's charter calls for the obliteration of Israel and justifies the killing of Jews worldwide. Posters and social media include images of tanks, Molotov cocktails, and Kalashnikov rifles.
Campus protesters in their social media posts call for the destruction of Israel, quote, from the water to water, end quote, for global intifada, for death to Jews, death to Zionists, and display inverted red triangles, a symbol employed by Hamas to identify targets for assassination. Professors encourage and sometimes require for-course credit, participation and support of protests and actions that frequently amplify these terror messages and symbols. Some even celebrate October 7th massacre.
So as scholars, we support the efforts of this government in addressing rising hate in developing C-9. We support the recognition of C-9 of intimidation and impeding access to space. As we have illustrated, terror symbols and the promotion of terrorist ideologies are key tools for propagating hate on campuses. We support the proposal by Mark Sandler and ALCCA that a separate charge of willful promotion of terrorism should be introduced, as well as the amendment to the bill dropping the requirement for evidence of hateful intent when terrorist symbols are displayed.
We're
close.
speak to you today as professors who research anti-Semitism with examples from campuses across Canada. Hatred undermines the university's mission of advancing knowledge and training future Canadians. Hatred impedes the free flow of ideas that drive innovation and creativity essential to the future of Canada. When identity-based hate is allowed to flourish on campus, no one is safe. Ultimately, all of society is diminished. Thank you.
Thank you, Mr. Silver.
Honorable député, merci.
Honourable members of Parliament, thank you for giving me this opportunity to address the committee. This study on the hate crime bill is very relevant at this time when we are experiencing a real crisis of hatred.
Here over the past 5 years, with nearly 20,000 incidents reported by police. Most of these crimes target Canadians based on their race, religion, or sexual orientation. This rapid rise is underpinned by what feels like a culture of impunity surrounding incitement to hate. History has taught us that the most unspeakable of crimes begin with incitement. The Holocaust did not begin with gas chambers, it began with words. The stereotyping and dehumanization of Jews, in the same way that the killing fields of the genocide against the Tutsi in Rwanda started with radio propaganda calling them cockroaches. The Supreme Court of Canada enshrined this principle in law, affirming that Léon Mugesera, who was then living in Quebec, was responsible for participating in the genocide against the Tutsis due to his hateful speech and should be deported, even if he hadn't been in Rwanda when the killings themselves occurred. In the hate speech trilogy of Supreme Court cases in 1990, Keekstra, Taylor, and Andrews, the court affirmed the constitutionality of restrictions on hate speech. This was further enshrined and refined by courts in the subsequent decades, always holding that hate speech can be proscribed in compliance with the Canadian Charter of Rights and Freedoms. Not only are hate speech prohibitions not in breach of the Charter, they actually help protect it. Hate is an assault on the inherent dignity of the person, on the equal dignity of all people, on the right of minorities to protection from group vilifying hate, and on Canada's international treaty obligations. There is no right to use one's freedom of expression to infringe upon the rights of others. The Combating Hate Act makes a meaningful contribution to protecting Canadians and promoting human rights in the face of rising hate crime. The provisions on hate symbols and the targeting of community institutions are particularly important as a matter of principle and policy. Banning the willful promotion of hatred against an identifiable group by displaying specific Nazi or terrorist hate symbols in public addresses a leading form of incitement today. These hate symbols represent violence and are anti-democratic in nature. Such expression vilifies and excludes targeted minorities, incites harm against them, and undermines broader human rights norms. Neo-Nazism and any of the designated terrorist groups are a danger to Canadians. Their hate symbols send a clear message. A Nazi symbol tells Holocaust survivors they are not safe or equal in Canada and encourages white supremacists to act against them. The ISIS flag tells Yazidis and minority Muslim survivors of terrorist atrocities such as the Ahmadiyyas and Ismailis that they are targets in Canada and encourages Islamist extremists to act against them. These are hate groups that murder, maim, and menace Canadians and seek to dismantle democracy. That is what their symbols represent. Criminalizing the intimidation or the impeding of access to a community institution associated with a minority group, such as a daycare, seniors' residence, or place of worship, protects the freedoms of vulnerable people. No Canadian, whether a Jewish toddler being dropped off at daycare, a Muslim going to mosque, or an LGBTQ+ person attending an event at their community center, should face hateful harassment and obstruction in their neighborhoods. Now, there are always legitimate legal debates surrounding any legislation being proposed. However, saying that one's constituents cannot express themselves without resorting to willfully promoting hate in Nazi or terrorist symbols or obstructing access for vulnerable groups to their crucial communal institutions says much about the nature of their intended expression. These elements of Bill C-9 are a necessary and narrowly tailored response to a massive rise in hate crimes and a reaffirmation of principles that Canadian courts have already upheld for decades. But to truly effectively combat hate crime, legislation must be followed by government leadership. The Prime Minister and his cabinet ministers should make it a habit to visit victims, offer them comfort, and to immediately and unequivocally condemn hate crimes when they occur. As well, the government should mobilize federal, provincial, and municipal law enforcement and leaders to move together in common cause. For example, the government can convene the federal, provincial, territorial meeting of ministers of justice and public safety for a special meeting on combating hate crimes and create an FPT working group that meets regularly to enhance cooperation and effective enforcement in that regard. Les aspects de loi C-9 qui
The aspects of Bill C-9 that address hate propaganda and access to religious or cultural sites are essential. However, the government must show leadership beyond these measures. Thank you.
Merci, Monsieur Silver.
Thank you, Mr. Silva. Thank you, all witnesses. We will start the first round, starting with Mr. Barber, 6 minutes, and Madame Latencio, and then Mr. Fortin. As usual, you know the usual order in the second round. Mr. Barber.
I trust that you're aware of the fact that you're invited here both by the Conservatives and by the Liberals.
It's good to hear. Thank you.
I think that that speaks to your expertise on the issues to be discussed today. For 35 years, we used the Supreme Court's definition of the word hatred in Kigstra, an emotion of intense and extreme nature that's clearly associated with vilification and detestation. But the Liberal definition of hatred is an emotion that involves detestation or vilification. They remove the words intense and extreme nature, and instead of being clearly associated with vilification and detestation, they just want an emotion that involves them. Am I wrong to think that the Liberal definition of hatred prescribes a significantly lower bar to convict of hate speech?
You're not wrong in the sense that I wholly support the use of the precise language that the Supreme Court of Canada used in Kigstra to define hatred. Because I am concerned that the definition that currently exists arguably does lower that standard, particularly in the use of detestation or vilification as opposed to detestation and vilification, and some of the other points that you've made. I do not want any excuse for a challenge to the existing hate propaganda sections of the Criminal Code based upon a perceived difference in the standard set for hatred.
And you've heard some of the other witnesses today articulating a concern that the proposed definition is unconstitutional.
Well, My point is that the Supreme Court of Canada upheld the hate propaganda section of the Criminal Code on the basis that it set a standard for willful, it set a standard for promotion, it set a standard for hatred. And that's what made the section constitutional. So I do not want to interfere in the slightest with the standards that the Supreme Court of Canada set, which was the basis for its determination that the legislation is constitutional.
Bill C-9 removes the requirement of the Attorney General's consent for the allaying of hate speech offenses. Are you concerned that politically motivated crowns or police may initiate prosecutions that aren't appropriate? And specifically, to go further, that vexatious litigants may litigate private prosecutions for hate speech and appeal decisions that try to end or block such prosecutions?
So I am concerned, and I have expressed that concern for over 30 years, that the Attorney General's consent is a safeguard against the frivolous and vexatious use of these sensitive sections of the Criminal Code. That's why I've proposed either the retention of the Attorney General's consent, notwithstanding the difficulties at times in getting that consent or getting that consent in a timely way, or as an acceptable alternative that the consent be retained for privately initiated investigations, because that's the real danger, the privately laid charges.
The new standalone criminal hatred offense can be laid in response to any offense contrary to any act of Parliament. I find that to be very concerning because we may attract criminal prosecution for what is otherwise civil or quasi criminal legislation. Would you recommend that we confine the application of the hate offense to conduct that is truly criminal in nature?
Well, I definitely agree that the hate offenses should apply not to quasi-criminal offenses, but to criminal offenses. So if there is concern about the scope of the present provision, then one can either deal with it by confining hate offenses to the criminal code, or what I would suggest is specifying the acts of Parliament to which it applies.
Bill C-9 repeals Section 430, 4.1, mischief, targeting places of worship because of bias or prejudice. Going forward, hatred will be required. Doesn't that mean that it will be more difficult, or a conviction for mischief against religious property would be more limited in scope if this section was repealed, if someone was to desecrate a church or a synagogue or a mosque?
Well, let me put it this way, because in essence, I'm going to agree with you, but I'll frame it in my words. That's what lawyers do. What I would say is this, that I was an advocate when this section was created to show that the desecration of places of worship and other similar places be treated in a more serious way, and that's why this offense was created. And it need only require proof that the vandalization was based upon, was motivated by bias, prejudice, or hatred, which is a lower standard than hatred. I understand the use of hatred alone for direct offenses involving speech, but for the vandalism of religious institutions and the like, for me, this section should be retained as is. We shouldn't be making it more difficult to label the desecration of religious institutions as hate offenses.
I will take your invitation and I will phrase it in my own way, which is I believe that repealing this section will make it easier for someone to get away with desecration or mischief against a religious institution. Mr. Sandler, if a person intimidates someone as they're walking in, if they obstruct and intimidate someone as they're walking into their religious institution or their educational institution, isn't that already criminal under the criminal code? It could be mischief, it could be intimidation, it could be assault.
So as I said,
Mr. Sandler.
so the answer is yes. What I've said is that the current proposed intimidation or obstruction sections don't make criminal conduct that is not already criminal. In my view, they send a signal to those who would be minded to commit these offenses. They assist law enforcement in giving priority to them, and they enhance sentences for it, but they do not criminalize conduct that is not already criminal.
Ms. Latanzio.
Thank you, Mr. Chair. Thank you for being here today and providing us your insights on this important piece of legislation. My question will be directed to you, Ms. Hallett. First off, I just want to, as a former school board commissioner and mom of 3 kids, I just want to, commend the work of teachers that they do on a daily basis. And I profoundly believe that education starts at a very, very young age with our kids. And I think it is important, as you stated, that we provide them with a very safe environment conducive for them to learn and to explore and to have exchange of ideas and values and thoughts. With that being said, teachers across Canada are seeing more hate and intolerance in schools. So how can Bill C-9, in your opinion, reinforce the values that we see in the majority of our schools, which is safety, respect, and inclusion?
Very much. As I mentioned in my opening remarks, the Canadian Teachers Federation will really be in favor of any legislation that helps to ensure that schools can be sanctuaries where everyone, the students, of course, but also the education workers and teachers, feel safe. They're free from intimidation and harassment. And we're seeing, as has been said many times already in this room, an increasing rise in many forms of hate and violence across the country. So we do believe aspects of C-9, as well as potentially other legislation, which we'll speak about at other times, could really make a difference to ensure that schools are those sanctuaries. There's international declarations calling for schools to be sanctuary spaces. We don't see that being enacted in Canada. And we really do think that much greater clarity is needed in legislation so teachers can teach provincially and territorially approved curricula free from aggressive, hateful actions, protests, etc. And so that students who may identify from a vulnerable group can be safe going to school. That's one of our biggest concerns.
And so from your perspective, how does the law, Bill C-9, complement the work that teachers are already doing in order to build that inclusive spirit in their classrooms?
As mentioned, we appreciate the specific designation or reference to daycare centers in the legislation. There could certainly be more in the legislation related to schools, the K-12 system. Even though we recognize K-12 schooling are provincial and territorial jurisdiction, public safety is federal.
And can you provide examples of what work could be done?
We could certainly follow up with some specific language if that would be helpful.
Sure. You can submit something in writing to the committee and that would be looked at. Thank you. Over to you, Mr. Sandler. I just want to come back on the questions that were asked by my colleague, this idea of having a criminal offense and the civil component to it. And I'm very much interested in terms of, because we want to get this right. We just want to make sure that the law will have the effects that it's supposed to have. So in your opinion, I just wanted to have a clarification and a better understanding on the separation of the two and how you see it and how we can make sure that this piece of legislation would address exactly that hate and that it would be criminal in its nature.
Thank you for your question. I think what Mr. Baber was raising with me is the fact that the hate offense as currently defined applies to any criminal code offense as well as any offense under any federal statute. And so he raised a concern about whether or not any federal statute would incorporate quasi-criminal offenses that are created under other pieces of legislation, and as such undermine the purpose behind this, which is to address true crime. And I said that if there's concern about that, the way to address it is by saying that the hate offense section applies to the criminal code and specify the other offenses to which it applies, rather than leaving it open to all federal offenses that exist. Let's face it, this is going to be applicable, based upon my experience, in 99.9% cases to criminal code offenses.
Right.
So that's really where you want to strike at. Labeling offenses as hate offenses that are conventional offenses under the criminal code, but also have the hate motivation.
Thank you. I have no further questions.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, witnesses, for being here. Thank you, Ms. Hallett, Madam Butler, and Mr. Cogan, for your position in favor of our kids in our schools. My spouse is a teacher. I have children and grandchildren, and we are always concerned by the disasters going on in our school. Thank you for the work you do. Mr. Sandler, very quickly, as you know, I don't have much time. The criminal code in section 319(2) provides that any statement made in private and incites hate against an identifiable offense is committing a crime. Same for anyone inciting anti-Semitism. These two provisions prohibit inciting hatred or anti-Semitism are also associated with an exception saying that no one could be found guilty of the section if, out of good faith, they expressed a topic or an opinion on the basis of a religious text they believe in, and they could present arguments to justify that exception or defense. In your opinion, should it be withdrawn from the criminal code or should it stay in the criminal code?
So the answer is that when we originally argued this case in the Supreme Court of Canada, the court relied upon the existence of those defenses to uphold the constitutionality of the hate propaganda sections. So I have some concerns about how the religious defense is being interpreted, because I think it's over-interpreted in a way that people think it gives a defense to religious expression when it doesn't, based upon the words "in good faith." So I'm very sympathetic to your position that that defense should be omitted, and that willful promotion of hatred should remain constitutional, notwithstanding its omission. But I'm concerned that it would reopen the constitutionality of the provision. So it's with some reluctance that I respectfully disagree with removing the section, though I'm very sympathetic to why it should be removed in your view.
En octobre 2000.
In October 2024, a year ago, the Imam Adil Shakawi made a public statement in Montreal, and I will quote what he said: Allah, deal with these Zionist aggressors. Allah, deal with the enemies of the people of Gaza. Allah, count them all and exterminate them and spare no one. In your opinion, this statement, does it contravene the provisions of the criminal code, in your opinion?
He committed at least two offenses: the willful promotion of hatred against an identifiable group. He also committed the offense of inciting hatred likely to against an identifiable group, likely to lead to a breach of the peace. I heard that the position was taken that he was expressing a view on a religious subject. That's nonsense. The defense would not be available to him. It wasn't made in good faith, and it was simply the willful promotion of hatred. And it was no defense that he also used the term Zionist as opposed to Jews. He was using as a proxy for Jews, and frankly, it was a profound and disturbing call for the extermination of Jews, and should have been treated as such by the police.
Merci, Maître Sandler. Il reste pas beaucoup.
Thank you. I don't have much time left. Let me now move on to something. Overall, in C-9, there are lots of topics addressed and that I agree with, but are already in the criminal code. You discussed this with other colleagues who asked questions before me. Now, adopting a bill that duplicates what is already in the criminal code, is this not counterproductive, as it may be opening doors to interpretations that were not there before? Because we know that if we prohibit specifically something else, it may be because we are allowing something else. So don't you think this is counterproductive, this approach in legislation?
I don't, but I have to look at each of the sections. So when you look at the hate offense, for example, that is something that is being added that is new because it is labeling the offense in a different way than it's currently labeled. And by the way, it's completely consistent with even the more limited use of the criminal law in the United States. They have hate offenses in the same way as is being proposed here. The reason why the labeling is important is because a lot of the hate mongers are repeat offenders, and it's important that the criminal record labels their prior offenses in a way that prosecutors and police know that the prior offenses were hate motivated. That is not always apparent from looking at the record, and it provides for enhanced penalties if the Crown proceeds by indictment. So for me, that's not duplication. In terms of the intimidation and obstruction, because I know your time is limited, I'll answer very quickly to say it is already criminalized by other offenses. For me, the message I'm getting from police is that if we specifically deal with it in the context of access to places of worship and other places, that will give greater priority and attentiveness on the part of the police to utilizing these provisions effectively. So I recognize the duplication. I would normally agree with you that we don't simply duplicate for the sake of duplication, but for me, I think there's some important messaging through the use of those provisions.
Thank you.
Merci.
Thank you, Mr. Sandler. We'll do a complete second round, starting with Mr. Lawton, House Father, Fortin Gunn, and then Chang. The third round, I'll do some slicing and dicing to come up with something reasonable. So I'll get back to everyone on the complex math involved. But Mr. Lawton, please begin.
Thank you. Mr. Silver, you had alluded to the importance of political leadership, and I actually agree that in the context of C-9, we have to look at the broader context of hate and its origins. You would, I'm assuming, be aware in August there was an open letter signed by several Liberal members of Parliament condemning the rise of anti-Semitism. What do you make of the fact that only 31 Liberal MPs, a very slim minority, signed that letter?
The engagement by members of parliament from across all party lines in combating hate is something that's appreciated by the center I represent, and we take an all-party approach to our commentary on matters before the House.
Sorry, I'm not sure if you heard the question, sir. I asked, what do you think of the fact that only 32, I apologize, Liberal members of Parliament signed a letter denouncing the rise in anti-Semitism in August?
I would imagine that any member of the House, I would trust that any member of the House, given the opportunity to comment, would condemn anti-Semitism, and I, in my own experience engaging with members of the House, see that to be the case, that this is something that should be above partisan politics, the condemnation of anti-Semitism, and the strong support from all parties in the House on the matter.
Wonderful. So not signing a declaration condemning anti-Semitism is a bit of a problem. I'm glad we got there, Mr. Silver. Your organization's founder, Erwin Kotler, had actually advised Mr. Anthony Housefather, a Liberal member of Parliament, to leave the Liberal caucus over anti-Semitism at the Liberal Party. Do you agree with Mr. Kotler's advice?
I'm here representing the Raoul Wallenberg Center for Human Rights. You can feel free, you might want to consider addressing any questions about Professor Kotler's views on any particular electoral matter to him directly. I'd be pleased to comment on any aspects of Bill C-9.
But you did mention political leadership as being important. Do you think there has been leadership from the Liberal Party on anti-Semitism in the last 2 years?
So the references to political leadership were with regard to what tangible...
Sorry, I appreciate that. Do you believe there has been leadership from the Liberal Party of Canada in condemning anti-Semitism in the last 2 years? Yes or no?
So what we call for here is...
That is a yes or no question, Mr. Silver. Are you declining to answer?
condemning anti-Semitism.
Okay, I reclaim my time, sir, if you're not going to answer. I'd like to turn to you, Ms. Hallett. You mentioned protecting teachers against hate. So your concerns on Bill C-9, your engagement on C-9 regards to what you think is directed or what you're identifying as being directed at teachers, correct?
Partially correct.
Okay.
Our concern is for everyone in the public school system, teachers, students, education workers. We're deeply troubled by rise in hate against students from vulnerable groups, as well as educators from vulnerable groups.
Have you read the Government of Canada report, Anti-Semitism in Ontario's K-12 Schools?
I have not read that specific report. However, I've read many reports on increasing violence in schools and been part of many resources to create safe, inclusive spaces for our schools.
One of the takeaways from the reports is that of the thousands of incidents, a great many of them are anti-Semitic incidents, 1 in 6 anti-Semitic incidents involve teachers or school-sanctioned activities. Does that concern you, that teachers and schools are actually involved in perpetuating hate against students?
Any perpetuation of hate is a concern. I would not comment more on a report I haven't read and one statistic that's been pulled out of context for me, but I can assure you that the vast majority of educators across this country are doing their level best to create safe, inclusive environments for all of the students in their care, and they deserve the same as educators.
What do you believe should be available to students and families dealing with anti-Semitism when the person of authority, the teacher or the school, through a sanctioned activity, is responsible for it? That's what this report gets to, and I do hope you'll take a look at it after.
And I will. I won't speak specifically on Ontario matters, as we are a pan-Canadian federation representing the teachers' unions and educators across the entire country. But I can again assure you, as an educator myself, that in every province and territory, there are mechanisms in the teaching profession, in public schools, just as you find in other professions. If someone is out of bounds, so to say, if their conduct is inappropriate, if they, as the example you're citing, are inciting hate, then there are mechanisms for follow-up, appropriate channels for addressing that, for complaint, for discipline. Please don't think that that's any different than another issue. There's absolutely recourse if someone is conducting themselves inappropriately. Thank you.
Thank you, Ms. Hallett. Mr. Housefather, for 5 minutes.
Thank you, Mr. Chair, and thank you so much to the witnesses. I note that 2 of the different witnesses, Mr. Sandler and Mr. Kogan and Dr. Butler, appeared before our committee last year on the anti-Semitism study, and that C-9 puts into effect many of the recommendations from the Justice Committee on the anti-Semitism study. I would also note that the letter that was referred to by my colleague, Mr. Lawton, actually endorsed each and every one of the recommendations from the anti-Semitism study, some of which Mr. Lawton doesn't endorse. So he would not have signed that letter. And I don't think it was a simple condemnation of anti-Semitism. It was actually a detailed request to government to implement measures, many of which are reflected in this law, C-9. So let me ask, Mr. Silver, do you agree that regardless of whether some of these measures in C-9 would essentially reformulate certain elements in the criminal code, that they send an important message to police and to prosecutors, and send an important message to provinces and municipalities that these are important to the federal government within our sphere of jurisdiction, that we want them to act? Because a lot of the complaints have been that they are not acting. For example, the intimidation and obstruction offenses. Do you feel that these intimidation and obstruction offenses will assist police in actually charging people who are blocking access to buildings?
Fellow witness Mark Sandler gave a very compelling and comprehensive response to some of those matters, which I would indeed echo. The signaling, from a deterrent standpoint to those in breach of the law, what it adds to their record, and also the signal it sends to law enforcement and to partners at every level of government that this is a matter that should be a priority, that there is a requirement for enhanced enforcement that has been a large part of the problem until now, and which is why my reference to political leadership also with some specific recommendations about the FPT, federal, provincial, territorial meetings by the relevant ministers and their counterparts at every levels of government have not been sufficiently utilized for hate speech matters, and whether for questions of enhancing enforcement and coordination, a specialized working group could be created after a meeting. And surrounding the questions of Attorney General consent, I mean, it's presented as a sort of zero-sum game between the current clogged system where there's not enough movement on approvals and removing it altogether. But perhaps the FPT can also be a forum for enhanced cooperation between levels of government on approvals of prosecutions by the AG. I think there's other alternatives that can be offered to ameliorate the situation in terms of providing the relevant consent at the federal level and in partnership with provinces, territories, and even municipally.
And you don't agree that the careful line that has to be drawn between the interplay of Section 2 and Section 1 of the Charter to limit freedom of expression in certain contexts, I think you expressed it very well, is violated by the terms right now or the clauses right now that are in the bill?
And I would add that, there are other relevant sections of the Charter as well. Section 15 on equality, Section 27 on multiculturalism. There are multiple Charter values that come into play, and quite consistent Supreme Court decisions throughout several decades that uphold that narrowly tailored restrictions regarding hate speech actually align with not only Section 1 being a valid restriction, but also uphold the other sections of the Charter that espouse core Canadian values. And to your earlier question on, obstruction, on hate symbolism, there is an additional component of very specific proscribed symbolism. That is new and it's important. And, I had emphasized in my remarks why these symbols incite hate, why they are anti-democratic. And that is an important addition to existing criminal restrictions.
Mr. Chair, do I have any time left?
35 seconds. Often, Brandon can answer.
My last question is to Mr. Sandler. Mr. Sandler, you had talked about, you agree, Mr. Sandler, that C-9 should proceed. You agree that it's important, and you agree that law enforcement will get a good lesson from C-9 to actually enforce provisions that previously we all agree they have not been enforcing, perhaps the new ones and old ones. Can I ask you about removing the words of hateful intent as well in terms of the limitations on flying the terror symbols? What exactly would you propose be changed in terms of what would you remove exactly?
Mr. Sandler, very briefly, or you can submit a written.
Very briefly, if you see my written submissions, I've set out a series of proposals that would more clearly tie the symbols to terror activities and would be a freestanding offense that wouldn't require proof of all of the elements of willful promotion of hatred. So I've set that out in more detail in my written submissions, Mr. Housefather. Thank you so much.
Thank you both. Monsieur Fortin, comme d'habitude, 2 minutes et demie.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Sandler, I understood from your testimony that you support C-9. That's good. I'm not sure I understood your position on the fact that the prior authorization of the Attorney General to prosecute hate crimes. C-9 is proposing to remove that requirement. Do you think it's a good idea, or should we maintain the prior consent of the Attorney General?
Well, I've said that I support C-9 with the qualifications that are set out in my written submissions. One of the qualifications is I do not support the removal of the Attorney General's consent altogether. So I see two alternatives. One is that you retain the Attorney General's consent as a safety measure against the misuse of these sections. The alternative is that you retain it at least in relation to private prosecutions, because that's where the real mischief will take place.
Merci, Professor Sandler. Professor Butler.
Thank you, Mr. Sandler. Professor Butler, I would like to ask you the same question. Sorry, I made a mistake. It's Mr. Silva. Mr. Silva, I'll ask you the same question. In your opinion, the provisions of the Criminal Code that require prior authorization from the Attorney General before prosecution, should we uphold them or remove them as C-9 proposes. Thank you, Mr. Faulkner. I share Mr. Sandler's opinion. I propose that there may be other solutions as well. We may create a more efficient system. The consent of the Attorney General may be more rapid, more efficient. We don't need to remove that consent to attain our objective. We could keep the consent, but come up with a more efficient process, an internal process, and a process in collaboration with other levels of government, the provinces, the territories, municipalities, and so on. I'm trying to speak French. Thank you.
Monsieur le député Gunn.
Mr. Gunn, 5 minutes.
Mr. Sandler, if the bill C-9 isn't amended significantly, if the provisions remain as far as the AG, removing the requirement for the AG consent and as well as the watered-down definition of hate, could you support this bill in its current form?
The simple answer is no. I want to see, I need to see movement on the Attorney General's consent, and I need to see movement on the definition of hatred.
Do you believe that you made some other points? I can't remember which question you were responding to, but you were talking about, I believe it maybe was a preacher in Montreal that you believed had violated the law as they are written. Do you believe that the laws in Canada, particularly those that pertain to the incitement of violence, are enforced equally and consistently across the country today?
Boy, that's a question that could occupy an hour of time. The bottom line is that I work with law enforcement right across the country. I do not believe that the current measures are enforced in the same way in every jurisdiction. Sometimes the laws are underutilized in some jurisdictions. That's not the case in other jurisdictions. So, no, I don't see an even application of the law.
Why do you think that is? Or why is that?
Well, I've set out in a discussion paper that was presented at the National Forum on Anti-Semitism a series of issues that I think have to be addressed. The first is that police officers have to be acquainted with all of the legal measures that are available to them to combat hate, and sometimes police officers are unaware of those provisions that exist. The second is police officers have to understand what forms of hatred exist in the context of anti-Semitism, what contemporary anti-Semitism looks like. They've got to understand what it means in order to apply the law effectively. And third, they have to be supported by whether it's municipal police service boards or municipalities, if they're municipal police forces. In other words, they don't direct the day-to-day decisions made by police, but they have to demonstrate a zero tolerance for anti-Semitism and other forms of hatred. They have to create policies on policing that should be implemented by the police force, and I see some of that not taking place right across the land.
With the concerns that you raised earlier that you then connected to not being able to support the bill in its current form, if the bill does pass in its current form without those modifications, what do you think are the what are the largest or most likely potentials for abuse, or the most worrisome potential elements for abuse?
Well, the two that concern me the most, the first is that I don't want to see in this highly politicized environment that we live in, private prosecutions being laid, for example, against Zionists just for being Zionists. And that's what we're going to see, efforts to weaponize the sections of the criminal code. And that could take place regardless of whether this legislation passes or not. But that's why the Attorney General's consent or the proxy that I've suggested for it is of concern to me. And the second is that although the courts may interpret the definition of hatred as being synonymous with the Supreme Court of Canada's decision, I don't want the risk of relitigating the existing sections of the criminal code and potentially coming to a different result. So those are two of the things that I would identify.
And just one final question that I had for you. There's been a lot of talk about some concerns surrounding the erosion of free speech and free expression in the United Kingdom and some of the laws there. It's not an area that I'm an expert in. From your opinion, is it justifiable to have concerns about the erosion of free speech and free expression and going down the road of essentially jailing people for making social media posts that some find distasteful or hurtful or even hateful?
Well, the answer is that I've proposed a new section, which is willful promotion of terror activity, because I don't like the looseness in the language that exists in the United Kingdom over glorification of terrorism, which I think is prone to the concerns that you've expressed. So for me, that's why I look at the terrorism sections that currently exist under the criminal code, and they're a hodgepodge, very difficult to apply for law enforcement, and law enforcement express concerns about it. And that's why I've crafted a potential section that's very narrowly crafted, that draws upon existing jurisprudence and recognizes that we do not protect under freedom of speech guarantees under the Charter the willful promotion of terror, in other words, violent activity. So I am concerned that we not go the route that the United Kingdom has taken. I don't think this legislation is doing that, and I certainly don't think that my proposed new offense would do that either.
Thank you. Thank you both. MP Chang for 5 minutes.
Thank you, Chair. Mr. Silver, do you think it's fair to say that freedom of religion and freedom from hate depend on each other, that both are essential to a safe and inclusive Canada?
Yes, and that's recognized in the Charter itself and in the precedent of the Supreme Court on hate speech provisions that were, as my fellow witness, Mr. Sandler, referred to, have been litigated in the past. They need not be relitigated. Protecting vulnerable groups from group vilifying hate ensures their equal participation in society, and anything less is an erosion of democratic norms that allow the fulsome participation of every Canadian, regardless of their background, in public discourse and in living their lives freely.
Thank you. Your organization has long championed for the protection of human rights and fight against anti-Semitism around the world. How does Bill C-9 advance Canada's broader leadership in these areas?
Well, there was a reference as well in my remarks to Canada's international obligations. And while the focus has been largely domestic and quite understandably so in terms of existing precedent and policy, there's also a corpus of international law that this dovetails quite effectively with, mandating the upholding of equality protections and also validating prohibitions on group vilifying hate. So this also brings this legislation, and particularly the components that I referenced in my remarks, bring Canada's legislation as well in line with international standards. This is something that has, again, been decided domestically by the Supreme Court, and also there is a corpus of international law and a number of international cases that uphold the legality of these provisions.
Thank you. This bill focuses on protecting access to religious and cultural spaces from hate-motivated interference. Why is this kind of protection especially important in today's climate?
Well, as I referenced in the opening of my remarks, in the last 5 years alone, there's been an increase to 20,000 hate crimes. There's an exponential growth, and there needs to be a concerted effort to address it. Now, this legislation is certainly not a panacea. It won't provide all the answers, but I think the important signaling that it does, the deterrence effect that it may have on would-be criminals, and the prioritization it would encourage by law enforcement makes a meaningful impact in trying to tackle what is indeed a crisis, and not doing anything would be far worse.
Thank you very much. And my next question is to Mr. Hollett. From your perspective, how does this legislation like this complement the effort teachers are already making to create inclusive, welcoming learning environment in Canadian schools?
Thank you for the question. I believe I touched on this earlier insofar as the legislation, as we've reviewed, really only focuses on daycare centers in terms of a specific education focus. So whilst the Canadian Teachers Federation welcomes that aspect of the legislation, there's not a lot in it that's specific to the K-12 school system from our perspective. Does not mean it would be unhelpful, but we are really eager to see much more being done at all levels of government to ensure that schools are safe for, as I've said before, students and all of the education workers in the schools. So it's not counter to making schools safe necessarily, but it doesn't go very far in terms of K-12 schools.
Thank you. My last question would be, how can this legislation empower our communities to respond more effectively when hate incident occurs, not just through justice system, but through education and prevention?
You know, a piece of legislation, again, if I speak on behalf of educators, will only go so far. But however, if we can make strides in Canadian society to condemn hate in all its forms, that will be something that has a trickle-down effect for our educators and for their students, because as a society, we will be improving in terms of ensuring that we know hate in all its forms, whether it is anti-Semitism, anti-2S LGBTQ rhetoric, et cetera, is not acceptable. So certainly legislation that promotes safety and freedom could be helpful, but the specifics of how C-9 would help in K-12 schools, I think it would take some time, respectfully, to see how that would bear out.
Thank you.
Thank you.
Thank you. We'll have about another 10 minutes of questions, starting with Mr. Baber, then Mr. Chang, 4 minutes each, and then Monsieur Fortin to close things all off with 2 minutes.
Mr. Sandler, I appreciate my friend MP Gunn's exchange with you on the equal application of the rule of law. Every Sunday in my riding in North York, a bunch of thugs show up in kafiyas and they scream for intifada. The basic translation of the word intifada is violent resistance, and yet no arrests ensue. Let me ask you something. Do you believe that calling for intifada on a Canadian street is incitement to violence?
I believe it definitely can be. The only reason I put a qualifier on it is because I always, as part of my training, instruct police to look at all of the circumstances and all of the words said in determining whether the requisite intent exists. But it is definitely capable of that, especially when coupled with other language that is clearly either genocidal or hate-filled.
If they have a character dressed and role-playing Yahya Sinwar, the mastermind of October 7th, would you call for the chance for intifada, incitement to violence?
Well, I've taken the position that some of the demonstrations that you're describing did cross the line into hate speech.
And yet no arrest from the Toronto police?
It's been very challenging to address situations where they do not involve kind of traditional forms of hate. So when you're doing the intersection of anti-Zionism and anti-Semitism, there has to be a better understanding of what's being said and when it crosses the threshold into hate. So when people are chanting, all Zionists are evil, genocidal, and racist, regardless, without distinction, you know, that crosses into hate speech. That's very different than criticizing Israel, its conduct, its policies, its government, and the like. And those distinctions have to be better understood.
Mr. Sandler, it's okay for us to politely disagree. All I ask is for equal application of the rule of law, something that regretfully we're not seeing in this context, and we're hearing deafening silence from my friends the Liberals across the aisle on this. And this bill does not do anything to address any of that, because all of that is already contrary to the criminal code. I heard you say in your opening remarks that you're disappointed that willful promotion of terrorism did not make it into this bill. I'd like to take an opportunity to remind you that the former Conservative government passed promotion of terrorism into the criminal code as a criminal offense, and that in 2017, the Liberal government under Justin Trudeau diluted that law, in fact, repealed some portions of that law, leading it to remain as only a counseling terrorism offense. Please talk to us a little bit about willful promotion of terrorism. What do you like to see added, and do you believe it will survive constitutional scrutiny if framed correctly?
Well, I have no doubt that it'll survive constitutional scrutiny because I've drafted the legislation for the consideration of this committee. It's contained in my written submissions, and I've drawn upon words that have already been constitutionally protected: willful promotion of, and then instead of hatred against an identifiable group, dealing with terror activities or the activities of a terror group, both of which terror activities and a terrorist group are defined already under the criminal code. So for me, there can be no constitutional protection for the willful promotion of terror activities or the activities of a prohibited group under the criminal code. So you can look to my written submissions for some of the language. For me, this would solve a number of the issues that currently exist.
Like what?
For example, when there's a fight about whether or not it's willful promotion against an identifiable group, namely Jews or Israelis, as opposed to whether it's political speech against Zionism, that shouldn't be the focus in all instances. The focus should be on whether you're promoting terror activities, and this would put the focus where it belongs for some of these cases.
Thank you. Thank you, Mr. Sandler. Ms. Dillon for 4 minutes.
My questions will be directed to Mr. Silver. First of all, thank you so much for your incredible testimony today. You actually got to the bottom of something that hasn't been mentioned thus far, which is words. It takes words. It takes hateful literature, propaganda to start something. And you gave the examples of the Holocaust and the Rwandan genocide. This was very, very important to the work we're doing here today. Not 10, not 15 members of the Jewish community, but 6 million were subjected to the Holocaust. This all started with words, and thank you so much for pointing that out today here. And during the previous panel, I was actually having the same thoughts as you, that symbols are used to emphasize these things. It's the Nazi symbol, the Confederate flag. These were symbols used during the convoy right here in Ottawa. The Confederate flag, the Canadian flag being hung upside down, the Nazi sign painted on the Canadian flag, Conservative members of Parliament serving coffee and donuts to these people. Everything that happened was to intimidate and harass citizens. It was an attack on democracy. Can you please talk to us a little bit more about words and propaganda and hateful literature, as you were mentioning in your opening statement? Thank you.
Thank you, MP Dillon, and without opining on any particular, instance within Canada, the legislation itself is incredibly important in identifying specific symbols that are used in the willful promotion of hatred. It's a very narrowly tailored an elegant piece of legislation that tackles a growing problem. We see that the incitement that you so eloquently referenced in your remarks that underpin attacks against vulnerable minorities, these hate rallies that Député Fortin referenced, oftentimes they are accompanied by very specific symbols that have a specific context and with a specific and willful goal, and that is to intimidate vulnerable minorities and to ensure that some Canadians do not have equal access to their places of worship, to their schools, to their community centers, that they cannot live their lives fully and equally as Canadians. And these symbols are a part of that process, and this legislation makes an important point of pointing that out.
So much for that. And I think I'm running out of time. Quickly, there was something said about assaulting somebody because of how they look. And the other thing is, there are Holocaust deniers, and they use that as freedom of speech. Brian Mulroney said something very interesting in 2023. Firewalls were thrown up in the wake of the Holocaust, and this bonfire was reduced to flickering embers, but those firewalls, weakened by the passage of time and willful neglect, have been breached. Cloaked in the armor of free speech, fueled by hate, and stoked by the oxygen of the internet and social media, those fires now burn out of control. This applies in this context, but do you believe that this applies to other contexts where there are minorities, there are people from the LGBTQ community? Do you see these fires being stoked once again, and see the slow erosion of civil liberties and all these rights of those who are vulnerable being violated? Thank you so much.
We won't have time for an answer, Mr. Silver.
If you can please give a written,
and that would be acceptable to us. So.
to give a written answer. Thank
Absolutely.
you.
Monsieur Fortin, 2 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Madam Hallett, I have only 2 minutes, but I will give them to you. Please tell us about the impact against hate symbols on our teachers and children in schools, and if possible, could you distinguish between the types of symbols we are talking about? Is it symbols identifying a criminal organization, or symbols identifying a terrorist organization, or any other types of symbols? In 2 minutes, please tell us the impact these symbols have on children and teachers in your schools.
Oops, merci beaucoup.
Thank you very much. Unfortunately, throughout the country, we are seeing a rise in violence and assaults in our schools, especially at elementary level. In our research throughout Canada, we have seen that there are indeed symbols influenced by social media, and this has a negative impact on our kids. To the extent that some don't feel comfortable and safe in schools. Others feel that they may become more aggressive because of the symbols. Do you have specific examples of the types of symbols? For example, we know that there were some T-shirts, Hamas flags. Let me think of the example in New Brunswick. We have symbols like cards that were sent by post against the LGBTQ community. It was clearly against that community, and that had a very negative impact on our children. And there are other examples throughout the country that we can share. Thank you very much. Thank you. Unfortunately, the time is up.
Sure. Yeah, but I just want to let's thank the witnesses, and thank you for this was very helpful to the committee, and indeed this will probably translate into our views on the legislation. So I want to take the chance from the chair's position to thank all of you for that testimony today.
Before the witnesses are dismissed, Mr. Chair, I just wanted to say I ran out of time before I could get to Professors Butler and Kogan, but I sensed they had a response to the government's report on anti-Semitism in Ontario schools, and I just wanted to ask if we could allow them to provide a written submission on anything they wish to share on that to the committee.
Absolutely.
Okay. Thank you very much.
Thank you.
Sorry, I wanted to get to you, but I ran out of time. Thank you.
Thank you.
And on that, I wish everyone a great Friday and a great weekend. Go Jays.